So, good morning to everyone. We are going to start the third session of the workshop, and we have two speakers this morning. We are going to start with Professor Bernard Koch. He's an old friend of the Faculty of Law of the University of Girona. It's a pleasure to have him here again. Professor Bernard Koch studied law in Austria, in Innsbruck. And then he did a doctorate courses in Tübingen in Germany, which he completed with summa cum laude in 1992. And afterwards, he studied in the United States. He finished a master's degree in Michigan. And then he completed his habilitation for private law and comparative law in 1998. Bernard Koch holds chair of private law at the University of Innsbruck, and among other memberships, he's a member of the European Grupo on tort law. He has published extensively in the field of tort law. He has also worked as a vice director of the Austrian Academy of Sciences Institute for European Tort Law. And today he's going to speak about proportional liability for causal uncertainty, how it works on the basis of a 200 years old code. Bernard, you have the floor.
Thank you, Albert. Yeah, here we go. All right, good morning. Please allow me two preliminary remarks on this. First of all, when I say how it works on the basis of a 200 years old code, I literally mean it, because the Austrian Civil Code has just turned 200. We're celebrating for 2 years because it was published on the 1st of June, 1811, and entered into force on the 1st of January, 1812. So partying all time, as you can imagine. And then, as a bit of a commercial break up front, when I cite to the Civil Code, I use the English translations provided by this neat publication available in a bookstore near you. Okay, second preliminary remark. Before diving into the substantive law on causation, I need to put this into perspective from a procedural point of view by indicating the relevant standard of proof under Austrian law. Traditionally, all parties have to establish the facts that support their case with a probability close to certainty, which in German reads mit an Sicherheit grenzender Wahrscheinlichkeit. However, in practice, courts have long resorted to requiring just a high degree of likelihood without specifying what high means, even though a mere preponderance of the evidence clearly does not suffice in the standard case. There are a couple of exceptions to this general rule, however, such as, of course, the acceptance of prima facie evidence, or a somewhat lower standard of proof in cases of omissions. In such cases, it suffices for the claimant to prove that the omission significantly increased the risk of her loss. And then medical malpractice cases are also treated differently and more favorably for the claimants. In such cases where the patient complains of the doctor's failure to provide adequate treatment in due time, it suffices to show a high probability that she would not have suffered the injuries at stake if the defendants had acted as necessary under the circumstances. And then the burden of proof shifts to the doctors/hospitals, and they have to prove with a higher degree of probability that it wasn't actually them. But that's especially for medical malpractice cases. And now to the essence of my topic, causal uncertainty under the Austrian Civil Code. Now, the ABGB does not expressly state the conditio sine qua non or any other fundamental notion of causation, even though it at least hints at the requirement of a causal link in section 1294, according to which compensable loss must arise from some external cause. But that's about it. However, there are two provisions in the Civil Code which deal with specific problems of causation. The first one is section 1301, and this provision says that two or more persons can be held liable for the same unlawful harm if their behavior has contributed thereto jointly, be it directly or indirectly. The code itself gives the examples of inducement, threat, orders, assistance, or the like, and furthermore explicitly mentions the failure to prevent harm, which only applies, of course, if preventive action was specifically required under the circumstances. The next provision, Section 1302, then specifies how these multiple tortfeasors are to be held liable. If they had acted merely negligently, and their individual share in causing the loss can be ascertained, they are only liable for the portion of the loss each of them is proven to have caused. If they inflicted harm upon the victim intentionally, however, or, more importantly in this context, if the exact shares of each contribution cannot be determined, liability is joint and several for the whole damage. However, the exact wording of Section 1302 still requires that each of the tortfeasors has caused at least some loss. Now, this limited notion becomes obvious if one looks at the history of these two articles. The predecessor of the ABGB, the so-called West Galician Code, which was introduced in 1797 in a southern part of what is now Poland, but at the time belonged to Austria, had already addressed the issue that subsequently became the provisions just cited. In its third part, sections 459 and 460 had already said just about the same thing, though emphasizing even further that the joint tortfeasors were considered to act with united forces and intent. So it is really the idea of cooperation, collaboration. Franz Zeiler, who is considered to be the father of the Austrian Civil Code, elaborated that understanding further in his commentary to sections 1301 and 1302. He argued inter alia that the prime reason to hold multiple tortfeasors jointly and severally liable for their negligent conduct, in case their individual shares are indeterminable, is that it were easier for them to figure out who has to bear which part of the loss. After all, Zeiler went on, they had been closer to the action, and because of their collaboration, had more insight into the circumstances, allowing them to identify their individual shares when seeking recourse. So to sum it up, the only scenario of uncertain causation covered by the plain text of the ABGB involves multiple joint tortfeasors in the narrower sense, where all of them were certain to have caused at least some part of the loss, but it remains unclear which. The solution offered was to shift that risk to the tortfeasors and let them figure it out, alleviating the victim, therefore, of the danger of losing her case against any individual tortfeasor. While this originally only applied to actual collaboration, it soon became accepted that also a mere coincidence of multiple harmful conduct should be solved on the basis of these two articles, thereby going already beyond the historic intention of the legislator to focus on cases of actual cooperation as well as aiding and abetting. In light of that restriction of Section 1302, this provision does not fit exactly the classic cases of alternative causation, often illustrated by the so-called Hunter's cases we heard about yesterday already. Apart from the fact that one wonders how such problems can still arise today at all, particularly with modern-day ballistics, it is quite astonishing that indeed these cases seem to reappear even nowadays, mostly involving lead and steel shots. From a legal perspective, the problem is that the classic conditio sine qua non approach does not help us here. If you disregard the conduct, for example, of Hunter X, A may still have been harmed, but this is equally true for Y and Z. This would at first sight force us to conclude that neither of the three can be held liable, which of course is pretty bitter for A. And footnote, this is by the way the solution offered in Switzerland, even today. Section 1301 and 02 won't help us here. After all, none of the three Hunters is proven to have caused at least some portion of A's loss, which Section 1302, as explained, requires. All three may have caused zero loss, despite acting carelessly. Until the middle of the past century, courts have worked around this code language restriction by pretending that all three Hunters had acted jointly in one concerted action, out of which the damage then arose. Therefore, the three Hunters could be sued as participants in this one action. This workaround failed, however, of course, if one of the Hunters was on her own or had not shot at all at the magic moment, but it remains unclear which of the three. It took almost 150 years from the publication of the ABGB to resolve that problem, when the Austrian scholar Franz Bydlinski started to publish his seminal works on causation. As he explained, in the cases addressed directly by sections 1301 and 02 ABGB, where the exact causal link between the defendant's conduct and the harmful outcome is missing because their exact share in causing it remains uncertain, liability already there is based upon the mere likelihood of causation in deviation of the conditio sine qua non, though subject to a violation of a duty of care. He therefore concluded that the ABGB itself did not require the conditio sine qua non to be fulfilled under all circumstances, which is why he argued that also cases of alternative causation could equally be solved by the principles embodied in these provisions, even though these are not exactly on the point and therefore would have to be applied by way of analogy. Hence, if it is proven that less than all potential tortfeasors have actually caused a loss, but it cannot be resolved with the required degree of certainty who out of these suspects indeed set the cause, all of them shall be held liable jointly and severally. Bydlinski developed his theory on the basis of the following hypothetical. 20 cows escaping from a field trample over a neighboring piece of land and destroy the lawn. It is clear that at least one cow is from X's herd and another one from Z's herd, with the remaining 18 cows belonging to either X or Z. There are three different facets to this case. 1/20th of the loss each is indisputably attributable to either X or Z. Another 20th was therefore with equal certainty not caused by one of Z's or X's cows respectively. And for the remaining 18/20th of the loss, it cannot be clarified whether and to what extent this segment was caused by cows from either X or Z. Now this is the exact scenario that the wording of section 1302 ABGB is designed for, as it requires both certainty with respect to at least a minimum fragment of the total loss and uncertainty with respect to the remaining overall portion attributable to either tortfeasor. Therefore, X and Z are jointly and severally liable for the whole loss, and whoever is sued first can seek recourse from the other. However, Bydlinski argues that it must not make a difference to the outcome of the case whether it is certain or not that X and Z had at least one cow among the 20 if they can be held liable for the uncertainty with respect to the remaining 18, as section 1302 does, which is why this provision should apply by analogy also to cases of the hunter's kind. If, however, in a variation of the hypothetical, it were clear that Z had at least 16 cows in the herd from which the 20 escaped, and X up to a maximum of 4, though at least 1, it would be unfair to hold X liable for more than 1/5 of the total damage, as that corresponds to the maximum she may have caused, and the uncertainty, of course, only affects the portion of the overall loss. Each tortfeasor in the court cases falling under section 1302 has caused at least some harm for sure, which evidences the actual and concrete dangerousness of their respective conduct. Now, while the latter is not equally obvious in the hunter's cases because not even a minimum loss can be proven for each of them, this requirement of a high degree of dangerousness should be maintained also in those scenarios according to Bydlinski. With respect to each of the hunters, it should be at least highly likely to the degree required by the standard of proof that they had caused the injuries in light of the factual circumstances of the case, if one imagined that none of the others had been there. Helmut Koch gives the example of a case hypothetical often used as a deterrent against proportional or even joint and several liability of multiple tortfeasors. A invites X, Y, and Z to a party at his home. The next day, A discovers that a piece of art is missing from a room that was easily accessible to all three visitors. Some claim that it were unbearable to hold the three guests jointly and severally, or instead proportionally liable for A's loss. However, that is not the outcome of the case anyway, since neither X, nor Y, nor Z were proven to have done something wrong, as being a guest per se is not forbidden, at least upon invitation. And none of the three behaved in any way that bears a strong likelihood of stealing. Obviously, those who conceived that hypothetical had problems with guests in the past. The internal recourse between these joint tortfeasors in the absence of any prior relationship, such as a contract, depends upon the weight of the reasons for establishing their liability in general. In particular, their respective degree of fault. If there is insufficient evidence for differentiating on the basis of these arguments, all tortfeasors have to bear an equal share in the overall loss per capita, since they are only jointly and severally liable vis-à-vis the victim, but not amongst themselves. Witlinski's line of reasoning was soon commonly accepted by doctrine and jurisprudence and can now be deemed undisputed. However, we are not talking of proportional liability yet. As demanded by Section 1302 ABGB, the hunters or any other multiple tortfeasors whose share in causing harm cannot be identified are jointly and severally liable for that loss. So how and under which circumstances do we end up with proportional liability as promised by the title of my presentation? This kicks in if one of the potential causes is not attributable to some third party, but to the victim herself, be it through her own conduct, some force majeure, or any other reason not attributable to the other person. For such cases, Witlinski adapted his theory one step further. He compared the competing interests of the potential tortfeasor on the one hand and the victim on the other. If the former has acted wrongfully and in a way prone, though not proven, to cause harm, it were unfair to let her go at the expense of the victim, barring the latter's potentially undeserved benefit of receiving compensation from someone who has not in fact caused her damage, to the full advantage of the former, who thereby would escape liability altogether, despite a certain distinct likelihood that she has indeed triggered a loss. Already at the time when Witlinski was looking into the problems of causation, courts were trying to circumvent our uncertainties by lowering the standard or even shifting the burden of proof entirely in order to ameliorate the claimant's position, as this seemed to be the only way to escape the boundaries of the code's straitjacket in an effort to reach a more equitable solution. I already mentioned the medical malpractice cases before. From that widely acknowledged court practice, Witlinski concluded that the traditional rule placing the risk of not being able to identify the true cause of a loss exclusively upon the victim were already obsolete. However, he rightly argued that playing with the rules of evidence, as the courts did, was merely falling into the other extreme by shifting the risk of uncertainty onto the merely suspected tortfeasors. Witlinski therefore searched for a compromise for the sake of reconciling both sides' interests. He found that compromise in applying the rule of Section 1304 ABGB to such cases. The latter provision is the standard rule for comparative negligence in the Austrian Civil Code. If fault in the sphere of the victim is proven to have contributed to causing her own loss, she has to bear a share of it corresponding to the degree of contribution, and if such percentage cannot be identified, in equal shares with the tortfeasor. Please note that the term fault used in this context is perceived to be different from the classic notion of culpa, inasmuch as you cannot actually be blamed for hurting yourself. After all, one is free to dispose of one's own interests at whatever will. If Section 1304 is now applied to a case of alternative causation, with competing causal influences both from external sources and from within the victim's own sphere, and if the latter impact is treated as if it were yet another external influence, the effective outcome is proportional liability, with the victim bearing her own loss to an extent corresponding to the likelihood that the cause was within her own sphere. After all, this would be the result if that cause were indeed attributable to some third party, who would be jointly and severally liable with the others, and ultimately, taking into consideration the contributions of the others upon recourse, bear a segment of the total loss corresponding to the number of potential tortfeasors, since all have to account for equal shares if their respective influence remains undeterminable. So the possibly causal influence from within the victim's own sphere is treated as if it came from some external source attributable to someone else. Admittedly, a somewhat schizophrenic approach if the victim did that analysis by herself. Witlinski's idea was met with both support and criticism in doctrine. After some decisions in favor and against his solution, the Austrian Supreme Court has meanwhile fully endorsed his proposal. One of the first cases where Bydlinski's solution was adopted was a medical malpractice case, originating actually in a hospital just across the street from my own law school. The plaintiff was born with severe permanent impairments due to lack of oxygen at birth. There were two possible causes of his deplorable state. One possibility was that he was effectively strangled by the umbilical cord, which was slung around his neck at birth, but unavoidable and even undetectable for the medical staff, according to the experts. The other possibility was a placental insufficiency which the doctors had failed to detect, so the mother was released from hospital after an examination shortly before the claimant's birth. He argued that if the doctors had performed a cesarean already then, he could have been born without the risk of asphyxia. By the time the case made it to the Supreme Court, it was clear that the failure to diagnose the placenta insufficiency was clearly malpractice, which, as a standalone cause, would have established liability of the hospital carrier. However, the courts below had already stated that it was impossible to decide whether this was the actual cause of the claimant's present condition, or instead, rather, this fateful placement of the umbilical cord, the latter being a risk, of course, entirely within the claimant's own sphere. The court extensively cited to Franz Bydlinski's works and argued that the traditional approach would lead to extreme solutions which were incomprehensible and unfair, since the choice would be full liability of the defendants, who may not even have set the true cause on the one hand, and no liability at all, even if the reverse were true. Both would contradict fundamental principles of the Austrian law of torts, as the Supreme Court said, which can be safeguarded by following the proportional liability approach suggested by Bydlinski. The Supreme Court nevertheless remanded the case to the lower court because the latter had failed to establish at what time the umbilical cord was slung around the claimant's neck. If this had not happened before the time when the doctors should have performed a cesarean upon proper detection of the placenta insufficiency, the latter would, of course, indeed have been the sole cause of the claimant's injuries. The most recent Supreme Court case confirming this meanwhile established case law is from last June, and accidentally also originating in the Tyrol, this time involving, more typical, a skiing accident. The claimant fell on a slope without any external cause, but as a consequence, he slipped into a snow lance. Now, for those of you who don't ski, this is a device to produce artificial snow. It looks like this. Not surprisingly, he ended up with broken ribs and bruises. However, it remained unclear whether these injuries were sustained already upon falling or only because he involuntarily embraced said snow lance. It was undisputed that this gadget had no cushioning, which instead would have looked like this. And obviously, it would have excluded the likelihood to cause bruises. Leaving aside the question whether there should have been more protection for that particular device, the Supreme Court repeated that if two potential causes coincide, which are both concretely dangerous, but of which one concerns the victim's own sphere, the loss should be split between the latter and the defendant in case of doubt in equal shares. This was the case here, as, in light of the closeness in time and space of the unprotected metal lance and the claimant's fall, both events were highly probable causes of the loss if one disregarded the respective other. The court further specified, though, that if the cause within the victim's own sphere is attributable to carelessness of himself, his share should be bigger accordingly. And this is supported by the general rule applicable to third-party multiple tortfeasors, where their internal recourse, as mentioned before, depends upon the weight of fault or other bases of each individual's liability. A case with a specific twist was the following. After being provoked and attacked by the claimant, the defendant punched back, knocking the claimant unconscious. The defendant then continued to hit the claimant, who ended up seriously wounded from several blows, though it could not be ascertained which injuries resulted from which blow. The problem in that case was that the first punch by the defendant had to be considered justified as an act of self-defense, for which he could not be held liable. This was not true for the continued beating, however, so he remained responsible for the consequences of the latter. Apart from the fact that the claimant was undoubtedly contributorily negligent for provoking the fight in the first place, The further complication was that this was an alternative causation setting, according to the court, with one and the same defendant, with the share of the total injuries attributable to the self-defense conduct on the one hand, and the remainder caused by unlawful conduct inseparably. The Supreme Court again argued that the reasoning of Bydlinski should apply and ended up with proportional liability, as the Supreme Court said. Since the degree of probability for either possible cause could not be ascertained in the instant case, the court concluded along the lines that both the claimant and the defendant would have to bear half of the loss if the claimant had not provoked the fight himself. But since he did, the court divided the loss into two hypothetical halves according to the two stages of the fight. The loss ensuing from the defendant's act of self-defense had to be borne by the claimant himself, whereas with respect to the injuries resulting from the second stage, the risk had to be shared in equal parts by both parties, resulting in the defendant's liability of only 1/4 of the claimant's overall loss. I personally think that the case is not a matter of proportional liability at all, and that the court got Bydlinski's idea all wrong here. The plaintiff caused it all with his provocation, but the cause stopped once the defendant continued to beat the already unconscious later claimant. So indeed, this should have been a case of two separate acts, which simply happened to be in a consecutive timely order. But I'll leave this for you to decide. It is important to note, however, that Bydlinski himself was very cautious in applying this novel solution, which he claimed was at the borderline of legitimate development of the law by way of interpretation and analogy. He held proportional liability only justified in cases of alternative causation if further criteria are fulfilled apart from a specific dangerousness of the tortfeasor's conduct. He proposed to limit it to cases of gross negligence, when there is a considerable degree of likelihood that the tortfeasor caused the loss, doubtful only because of a more or less equally possible impact stemming from the victim's own sphere. This way, Bydlinski argued, the shortcomings of causation could at least in part be counterbalanced by some element of reproach on both sides of the parties. Bydlinski's theory is actually an application of Walter Wilberg's concept of a flexible system. As you may know, Wilberg suggested to replace the standard concept of claims based upon multiple requirements which depend upon a weighing of interests with a less stringent model. Traditionally, if you take the example of tort law, the claimant has to establish the four key elements of a claim: damage, causation, wrongfulness, and fault, and all four have to be given, like in a checklist. However, Wilberg argued that in the real world, not all four elements are always given as formally required, even though courts often conceal the weakness of a single element in order to avoid the consequence of the claimant losing her case. In order to accommodate for the problems of real life, Wilberg suggested that if one element is not fulfilled to an extent commonly expected, that weakness of the claimant's case may be balanced by a particularly strong other element. So in our case, if there are doubts with respect to causation, but note, causation is still presumed to be given as a highly likely but just not entirely certain element, a particularly blameworthy and/or risky behavior of the defendant may offset that lacuna in an overall perspective. However, the courts that followed Bydlinski's reasoning only, but still require that the defendant's behavior was at least equally likely to cause the claimant's loss than the risks in the latter's own sphere, without adding the further requirements he mentioned. By opting for proportional liability, Austrian courts thereby have no incentive to even consider adopting a model along the lines of the French perte d'une chance, at least not in cases where the lost chance as such has no economic value of its own. For example, if it is the lost chance of being cured of a disease or other medical condition that is at stake. That interest in itself has no monetary value, since there is no price for the interest in improving one's own health. However, if the probability that it was a risk within the claimant's own sphere, such as a precondition, can be specified, and if it significantly exceeds the 50% benchmark, courts may disregard the defendant's possible impact on the course of events and therefore leave the loss with the victim entirely, which of course signifies a somewhat lax attitude towards the proportional liability model. If, on the other hand, the victim was deprived of her possibility to make a gain that she would have made for sure, but for the defendant's conduct, for example, because her ticket with all winning numbers on it was not forwarded to the lottery in due time, the loss of an expected future profit, she may have suffered a compensable damage calculable according to the objective abstract approach to assess her loss. The same is typically true for a client of an attorney who failed to take necessary procedural steps and thereby prevented the client from winning her case as she would have otherwise. As long as her damage has a price tag on it, which can be used to calculate the difference between her assets with and without the harmful conduct, her loss can be indemnified under Austrian tort law without resorting to the loss of a chance twist. If the claimant had an actual expectation of winning that was frustrated by the defendant, the former did not lose a mere chance but was deprived of a certain future profit, which are handled as items of the claimant's current patrimony, even if they would only have materialized in the future. Sample cases include fact settings such as a professional gambler who was denied access to a casino and therefore lost income. But even in that Supreme Court case, did the court not have to actually assess the loss. However, it is clear from the ruling that the claimant could recover a certain amount of money if he were to successfully convince the court of a certain regularity of winning blackjack games because of his extraordinary abilities to count the cards as they are played, which he was managed to prove. Despite strong support in the courts, academia is not equally strongly convinced of the advantages of Bydlinski's solution. Critics like Rudolf Welzer argue that this approach would ultimately hold anyone liable who acts culpably, but whose causal influence cannot be fully proven, even in those cases where the claimant had so far managed to surpass the threshold of the standard of proof, but failed to reach a 100% certainty. In such cases, the defendant is currently nevertheless found to be liable in full, of course, which critics fear would no longer be possible in strict application of Bydlinski's solution. Unfortunately, Welzer thereby neglects Bydlinski's aforementioned added requirement of a specific and concrete dangerousness which the cause within the claimant's sphere must fulfill. It is therefore not just any doubt concerning the defendant's causal influence that triggers proportional liability, but only if the doubts stem from another cause within the victim's own sphere, which, if the defendant's activity were missing altogether, would be considered the sole cause of the loss under the factual circumstances with at least a high degree of probability. Not every problem of proving causation is a scenario that falls under this model. The uncertainty may involve other external causes, such as some unknown third party or other possibilities why the loss ensued. More recent critics like Andreas Kretečka follow Welzer's reasoning also when it comes to his complaint that proportional liability in cases of uncertainty would hold the defendant liable for mere suspicion rather than actual damaging. Also, these authors argue that sharing the risk will never reflect the truth. Either the tortfeasor did cause the loss, in which case it would be wrong to hold her liable for merely a part of it, or she didn't. But why would she then have to contribute to a loss to an extent which she certainly never even possibly caused? However, one might also say that under the traditional approach based upon the all-or-nothing rule, the outcome of the case may even be 100% wrong, which seems even less desirable. Furthermore, critics of Bydlinski's approach contend that proportional liability were unfavorable for the victim. Not only is she just compensated for merely part of her loss, she also has to bear the procedural cost risk of suing for the wrong amount of compensation, which under Austrian law may mean that if her claim is reduced according to the probabilities of the case, she may wind up with a lower claim for costs and court fees than what she would have as a party winning the case in full. And she is further charged with the insolvency risk of each individual of several tortfeasors. Gerhard Wagner concludes, however, that the aforementioned lines of reasoning cancel each other out and in fact speak in favor of proportional liability. If proportional liability were indeed triggered by mere suspicion, as argued, it is even less acceptable to compensate the victim in full. Proportional liability, he argues, strikes a compromise between the two extremes of the all-or-nothing principle and is for that reason alone to be preferred in cases where both sides of that range are unsatisfactory. In his support for proportional liability in such cases, Helmut Koch puts a special emphasis on Bydlinski's argument that private law as a whole commands to respect both conflicting interests at stake. Therefore, it is imperative to strike a compromise in order to find a balanced solution where the stakes are not obviously in favor of either side. Helmut Koch has suggested to consider proportional liability also beyond the scenarios that Bydlinski had in mind. One such group of cases concerns problems of alternative victims, where someone is known to cause harm, but not to whom. On the one hand, if the tortfeasor were held liable in full, she would have to account for a loss she definitely did not cause, as long as it is certain that she injured, for example, only one out of the two victims. On the other hand, it would also be unsatisfactory to reject any claim against the tortfeasor because it is only uncertain which one of the victims she harmed, but it is proven that she did indeed cause harm to at least someone. Koch illustrates this at the example of a company emitting noxious fumes in a certain area which are proven to trigger every fifth contraction of a certain cancer type in this region. It is therefore clear that the company caused 20% of all cancer cases diagnosed after it commenced operations. However, any individual patient would fail to establish a causal link, since the likelihood of her own risk to develop cancer is 4 times higher, the remaining 80%. Still, it seems unfair to let the polluter walk away from a harm it undoubtedly caused. When looking at the element of causation, Koch argues that the certainty of the company causing at least some harm, which is missing in the standard cases of alternative causation, can step in to replace the requirement of a concrete endangerment of the actual victim in the overall assessment. Furthermore, if, for example, due to a pollution of a herd of cows owned by one farmer, had an increased risk of contracting a certain disease, the owner already now, under Austrian law, would undoubtedly recover the loss as quantified by the percentage of the risk. Not only were it unfair to treat the defendant differently just because the cows were owned by different farmers, but even more so if the victims were humans and not animals. This is particularly so if the latter were all covered under the same social security regime, with its provider seeking recourse for the combined costs of treatment. Even more so, proportional liability is suggested by Koch as a solution to scenarios like the DES cases, where there are multiple tortfeasors and multiple victims without a possibility to link individuals on either side. It is certain that all tortfeasors caused some harm. It is equally certain that all victims have been harmed, but who injured whom can no longer be identified with the required standard of proof. In such cases, the weakness of the causation element is lower than in cases of plain alternative tortfeasors, of whom at least some did not cause a loss, but it is equally beyond doubt that none of them caused harm to all victims. Therefore, splitting liability is even more convincing. In case of simultaneous events, of which each would have caused the whole loss alone, Bydlinski's approach is at least equally appealing, as it is clear in these cases that all events were indeed harmful, just not exclusively. Therefore, if one cause is within the victim's own sphere, proportional liability should be the outcome. Koch argues in such cases that the more the victim is to blame for her own conduct, the less percentage of the loss should be shifted onto the defendant, excluding liability of the latter altogether if the victim had acted by intention. In an interesting case on the point, the Austrian Supreme Court had to deal with an action filed by a pig farmer who sued the Austrian Television Corporation for lost revenues resulting from a TV report which not only showed footage of animal mistreatment on the farm, but also hinted at a potential abuse of illegal drugs on the farm. Now, the latter could not be proven, whereas the former was obviously the truth. The court found that both aspects of the report were in themselves reason enough to deter customers from buying meat from that claimant. But only one aspect, the alleged drug abuse, was a cause attributable to the defendant, whereas the former, the animal mistreatment, was a cause ultimately within the claimant's own sphere, despite the fact that it was the defendant who made this public. The court split the loss between the claimant and the defendant, arguing that neither cause could be seen as the preponderant element in the chain of events. Since 2005, a general revision of the law of delict is under debate in Austria, when a reform project authored by a working group installed by the Ministry of Justice was published. The original draft met with fierce criticism of some academics, and the most outspoken opponent subsequently produced an alternative draft by 2008. The status of this dispute is not entirely clear. Just last week, there was a hearing in Parliament on a compromise solution drafted by the Austrian Ministry of Justice. While even the fundamental question, whether the Austrian law of torts as codified needs reform at all, is disputed, among the many items where the two competing drafts differ are the rules governing causation. The original draft implements Bydlinski's approach, which comes as no surprise, as Bydlinski was one of the drafters. And it proposes proportional liability not only for the cases he had envisaged, inter alia, alternative causation, where one possible cause lies in the victim's own sphere, but also for any other instances of alternative causation. Note the emphasis on the combined assessment of the weight of the respective grounds for imputation and the likelihood of causation in the wording of the second sentence of this provision. This draft is based upon the solutions suggested by Articles 3103 and 3106 of the Principles of European Tort Law, though, unlike Petal, limited to cases of significant dangerousness of the potential causes, and not, for example, if the likelihood of one possible contribution is very small. The reason why the Petal were considered by the Austrian Drafting Committee were also not that much surprising, considering that members of the European Group on Tort Law were also members of the Drafting Committee. The alternative draft of the opponents of this original draft leaves the loss with the victim entirely, even in those cases where the Supreme Court already accepted the concept of proportional liability and thereby seeks to go back to the jurisprudence of the past. As you can see, the suggestion goes, if it is unclear whether culpable behavior or mere chance caused the damage, then the injured party alone must bear the damage. In light of the strong and consistent line of case law of the Austrian Supreme Court, I doubt that an amended code would ignore that. So I hope that the original draft, at least in that respect, will end up in the final revised text of the ABGB. The idea of proportional liability has stable support in Austria despite criticism of some academics. However, so far, courts have only applied it to a combination of external and internal risks. Therefore, for misconduct by some defendants and possible causes within the plaintiff's own sphere, such as medical malpractice on the one hand and a precondition of the patient on the other. There are other possible scenarios where a prominent tort law voice would also apply proportional liability, and it is not unlikely that courts would follow that lead if such cases ever made it to them. However, so far these other scenarios are hard to predict. It is also hard to tell whether proportional liability will ever be applied to the classic instances of alternative causation, for example, the Hunter's cases. This is promoted by one reform project as shown, but rejected by the other. Personally, I think the arguments brought forward in favor of dividing the loss directly rather than in a two-step process, joint and several liability with a recourse action afterwards, are convincing and they lead to satisfactory outcomes. I particularly like the Austrian requirement that the potential influences considered for distributing the loss must all have been specifically dangerous under the circumstances, which filters out such cases as a high degree of likelihood that D caused a loss competing with a low probability that the cause lied within the plaintiff's own sphere. A more in-depth comparative analysis of proportional liability is coming up, so a final commercial break of a new publication coming up this year, authored primarily by someone in this room, not me. Thank you.
Thank you very much, Bernard, for this amazing presentation. So now we have time for debate. I think there's one question. Professor Stapleton, please.
I could hear you anyway.
Actually, there's quite a small point, but 1304 of the code, was that in place 200 years ago?
Yes.
Was that unusual?
Pardon?
Was that unusual for a code to have comparative provision for plaintiffs'
I don't think so.
fault?
No, that was actually, I looked at the history of that provision as well, and At the time that it was introduced, it was not considered to be anything special. There was actually no debate on that point in the drafting commission in 1797.
So, relative to the common law, you were 150 years ahead.
Yeah.
Sorry, I just didn't know that. I was fascinated to find that.
Any more questions, yes, Professor Wright?
Yes. Thank you very much for the presentation. I'm hoping to get a full copy of it, which has more than the other one does that we have distributed beforehand. I had one question when you said that in the initial cow example, the cattle example, that if there were 2 out of 20 cows and one of those 2 was owned by each of 2 parties, that it was certain that they had caused 1/20th of the damage. Now, I mean, some cows eat more than other cows, right? So was that just sort of assumed, or is that just sort of taken as an assumption, or is it just sort of your assumption for purposes of exposition? And then I'm also curious, given my discussions about res ipsa, when you have the prima facie evidence sort of rule, I can't tell if that's phrased as the sort of situation where this would not have happened in the ordinary course of events, which is sort of more of, I think, a reasonable inference that happened in this case, or whether or not it's more, as in much in the U.S. anyway now, if it ordinarily would not happen, if most of the time it would not happen, which I think is a much less plausible sort of inference. So 2 different questions.
Okay, now the first one, the cow hypothetical, is not about the cows eating the grass, but they just trample over the grass. And so the weight of the cows is presumed to be identical. So.
Some cows move more than other cows.
Yeah, well, I think in the case there was no video of the cows actually trampling over the field, so you just had one part of the herd running over to the other field, and the end result was that it was all messy. So
Yeah.
not referring to the football player though.
Okay, so in the prima facie case.
Oh, sorry. Yes, you were asking how the approach is in Austria, or
Is the requirement for the application of the prima facie rule, is it that most of the time this wouldn't happen, or most of the time this wouldn't happen in the absence of negligence, or it would happen this way, or is it more that in the ordinary course of events this is the way it happens?
The latter.
The latter.
Yes.
So it's a stricter sort of way of phrasing it, which I think is better. Yes.
Yeah.
Okay. There's another question, Professor Rosenkrantz.
Just one comment and one question. The comment is the Austrian Civil Code influenced the Argentinian code. And this particular provision turned into something similar but different, which is the following. If the Argentinian code says that if something falls from a building, but you don't know where did it fall from, everybody is proportionally liable. And that was assumed as a matter of fact. Nobody really, it seems to be an equitable solution, right? And here is the question or the problem. When you move from these kind of cases to the case the hypothetical you just mentioned about someone pretending to make proportionally liable people for stolen property, we resist that. We think the compromise at that end is not proper. And I think the reason, as I tried to suggest yesterday, is associated with the fact that blame goes with it. Mm-hmm. So if tort law goes around wrongfulness, wrong, tortfeasors, I think the compromise is not a good idea. It's like compromising pro-abortion, anti-abortion militants, allowing us to work in one suggested, that would be unacceptable, obviously, to allow abortions on even days and prohibited it on uneven days. Mm-hmm. So I don't know how you react to that, but I think if we think that if we still want to maintain that tort goes around wrongfulness, transactions here are problematic.
Well, the Austrian perspective on that is a little bit more holistic. So we don't sort of work out down the checklist of damage, causation, wrongfulness, fault in that way. We see this more as a whole, and so more along the lines of what Walter Wilbrook then developed further in more detail in theory. But so the weakness, the not 100% likelihood of causation, for example, is not seen in an isolated way. So we don't look at the statistical evidence per se. We look at the fact that, for example, the defendant has acted wrongfully, culpably, highly dangerously, but you just simply cannot prove the causal link entirely. There is a certain degree of suspicion that the link was established, but the more blameworthy the behavior was, the more likely you will be able to compromise with respect to causation, but only, of course, if you disregard all other elements, and if that were the case, the defendant would end up as the sole cause. So the mere suspicion alone does not suffice. If somebody behaves wrongfully, culpably, but with no hypothetical potential to harm anybody else, then you don't punish that person for the misbehavior per se. There must be at least some element of probability. But you look at it from the whole scene, whole perspective. Does that come close to anywhere responding to your question? Or? Okay.
Any more questions? Borghetti, please.
Would it be possible to get 1294
The first
back? Or is that be too hard to do?
one? I'll try.
Oh, well, the language.
Which one?
Did you had the language of that provision at some point?
Just
down at the bottom?
those two. Or which ones do you mean?
Later on, near the end of the presentation, you had a slide that actually had the wording of 12.
The new draft, you mean?
The draft.
Oh, sorry, I misunderstood.
I'm
that.
sorry.
I thought the actual code.
I'm sorry.
I'm sorry.
I apologize.
I think.
There we go. My question was, the very last part of it, that last part that you talked about, I'd like to elaborate.
Okay.
The damage is to be apportioned according to, first, the weight of the respective grounds for imputation, and then I presume, and second, the likelihood of causation. I wasn't clear what the first thing meant, the weight of respective grounds for imputation, if that wasn't a question about causation.
No. I didn't do the translation, so, but what it means to address is the question of the basis of liability. So it's either fault or strict liability. But under Austrian law, in the meantime, even though at the beginning we didn't do it this way, but in the meantime, we think that fault and strict liability are on equal footing. So in case of fault, you're liable for faulty conduct. In the case of strict liability, you're liable for a certain risk that is in your sphere, that you control or sort of. And in either way, there's a way of balancing, or you can sort of weigh these various bases of liability. So you can act with a low degree of negligence or up to intent, and the same is also true in strict liability. So you can have a very small risk or a very dramatic risk, like a nuclear liability, for example, where the likelihood of harm may be slim, but the possible outcome is dramatic. And that's what is referred to. So if you have a low degree of negligence, for example, a minor degree of misconduct, that counts less than, for example, gross negligence or even intent. And the same is true if that were a strict liability cause. That's what is referred to. The respective grounds for imputation is actually fault/strict liability. So you need to have the causation element on the one hand, and the idea of the reason why you hold the person liable from a legal perspective, in addition to the actual causal link. And those two combined, and only combined, then are put onto the balance and then weighed.
The reason I found that interesting is that, I guess Mike probably knows more about this than I do, but there's quite a bit of controversy in American tort law when we do comparative responsibility about whether we're comparing fault or we're comparing causation. And in fact, some statutes are very ambiguous as to what you're doing. And I'd even say the restatement's a bit ambiguous as to what you do. And it sounds like this is an attempt to compromise that issue to some extent here.
Yeah. But I must admit, of course, the Austrian courts don't really do it in a clean way.
Right.
So they look at the case as a whole, and they just simply use text bits that sort of fit the image. And if they think you should split the loss here, they will use text parts and fit it in a way that sounds like it would fit into the provision. So in theory, it sounds great that you have these two elements as if they were really identifiable, which of course they're not. And of course, the courts never say, well, they never, of course, refer to any actual degree of likelihood, for example, with respect to the causation element. So they simply say this is beyond the threshold. So we assume that is given, so we have the causation checked, and we go for the basis of liability checked, and therefore they don't really do it in a clean way either. We just pretend we do.
We do it much better.
But no one complains.
We do it much better. We just give it to a jury and put it in a black box.
Professor Borghetti, please.
I would have a remark and a question on loss of chance, which is
What a surprise.
so which is, well, a French favorite, but at the same time used in different ways. So it's in French law I find quite complicated. But my reflection would be, but that's what I think something you hinted. But it seems to me that if you take the hospital case, the 1995 hospital case, seems to me that, I mean, yes, in France we would use perte de chance in that context, but the end result is very close to the one you get through alternative causation. So, well, we use different names, but I think the solution is the same there.
Yeah.
But then I wondered about perte de chance. So you say you can use that when there's an actual expectation of winning, and you take the example of the winning ticket. Mm-hmm. What if, because of my negligence, you lose your ticket, and you don't know if it was a winning ticket or not, but you had a chance to win, mm-hmm. and you lose your ticket. So can you claim, do you suffer damage here, even though it's not sure that you would have won, so you just had a chance to win?
Well, that depends upon the moment in time that you assess that case. So the actual case that we're talking about actually was a case where it was the negligence of the shop owner to forward the ticket. That was long before it was electronic. These cases no longer appear because they're all done electronically now. But the actual case that was before the Supreme Court was a newspaper stand person who collected these tickets, and she, for whatever reason, negligently failed to forward the ticket to the lottery. But it was not a case where you draw the ticket, but it's an actual lottery where the numbers are drawn otherwise. We're not talking about a ticket that has a number on it. And the court then said, ex post, this was the one single winning ticket, and would have knocked the jackpot, and therefore the negligence, it was sort of, by the time that you submit it to the newsstand, this is sort of on the run, and this is on the track towards winning. Because you shifted into the sphere of the lottery society, of which the newspaper stand person was considered to be a helper. It's an exceptional case. Personally, I think the circumstances of the case were a little bit dubious. Let's put it this way. And I personally think that it should have been solved differently because you actually look at the loss at the time that you cause it. You just have a chance of winning. So this was come much closer to the French approach, but the court said, well, this is such a miserable person. He had actually also claimed non-pecuniary loss because he knew which numbers he had on the ticket, and he watched the draw on TV and suffered a nervous breakdown because he didn't realize that the ticket was not actually in the winning. So I think the case was solved more on the basis of sympathy than on actual law.
Okay, and in the case of the solicitor who doesn't
Yes.
bring the appeal, file the appeal, because in some cases you might not know with certitude what the result of the appeal might be. So
I'm not talking about cases where it is unclear how the appeal would go. I'm talking about cases of prescription, for example, or time limits where you have to submit something within due time, and if you just miss that deadline, a pure formality. We're not talking about a case where it still is uncertain how the outcome of the case would be if you had a filed appeal on time.
And do you have those cases where it's uncertain what the end result would have been?
There are very few cases of that kind, but in that case, the court simply makes sort of a trial within a trial, and so assesses the outcome of the case, and then figures out whether it was a clear-cut case. So if it's just like, for example, a case where there was a clear problem in the lower court's decision, which would have been for sure overturned on appeal, but for the failure to submit the appeal on time, then the court would be sympathetic to the claimant. But if it's a question of discretion of the court, for example, you have no chance of winning that case.
Because those were that was actually the first loss of chance, the first case in France, and the court, that was in 19th century, and the court ruled, said, well, your chances to win an appeal were unclear, so basically we say you had a, let's say, 50% chance to get 50% of what you could have got, but you don't have that explicitly.
There's no court case yet, no Supreme Court case yet on that particular problem. So, but it's just mere guessing how the court would react to that. But I assume that the cases that we had so far were cases where it was not about, where you didn't have the situation where it was equally possible that the appeal would have been successful or not. So we had cases where the lower court had overlooked some detail where it was clear that had you submitted the appeal on time, the Supreme Court would basically, or the appellate court in that case, would almost automatically have reversed the case. And so, because there was a clear failure by the lower court judge. So there was not that kind of doubt involved. But generally speaking, I think that these cases are also influenced by the fact that lawyers have liability insurance. And so I suspect that these cases don't make it that much to the court.
Yes, Professor Grempas, please.
I have a clarification question about the pig farm defamation case.
Yep.
I think you mentioned that the court found that each part alone would be sufficient to cause deterrence, and the question is whether it was sufficient to cause all the loss or just part, because if it's all the loss, so it's overdetermined case, it's not a cumulative case, and then splitting the damage is more controversial. Now, to me, it seems that the cumulative interpretation is more plausible, because it might be that some people care less about animal abuse and more about drug, and so, but what was the finding of the Supreme Court on that?
The finding said it was equally possible. So if it had just been the report on the mistreatment, he would already have suffered exactly the same reduction in income. Or if it had been just the drug abuse.
Exactly the same?
Yeah, the court said it was exactly the same.
So this is interesting and to me more controversial because, again, well, at least it seems to me that the common law approach would be that it's a case similar to jobbling, that an innocent result would bring about the same result, and therefore there shouldn't be damages. But,
I mean, the finding of these, I haven't read the lower court decision, I've just read the Supreme Court decision, but the determination that both aspects of the report caused the same loss were a kind of heroic assessment, as we talked about yesterday.
Yeah.
I wonder whether there's any possibility to actually quantify that. I doubt that seriously. But I've actually seen the report at the time because it was a very huge farmer. It was a big scandal because he was also a peer and linked to the political party, the Conservative Party. So it was a big fuzz at the time. It was a very political issue, and you saw these pigs really, it was filmed with a hidden camera. And so I think I personally think that the mere images alone of showing the pigs and the circumstances of the pigs were even worse than the alleged drug abuse. I think people were worried more about the condition of these pigs on the farm, because these were really images, you know, you could actually see that. And I think the impact of seeing these pigs, blood dripping, running around in cramped circumstances was much more powerful visually than the alleged drug abuse, which was also in the report said, well, there are indications that they used, I can't remember what it was, to feed the animals. So, as I said, the court's assessment, the Supreme Court couldn't mess with it because it was a lower court decision of fact, and that's not on appeal, so the Supreme Court had to live with the fact that this was equally possible. It was explicitly stated in the lower court's decision that these were equally likely to cause the same loss.
Okay.
Of the pigs, yeah. In some sort of drug that they used in the feed or something like that. I can't remember what it was.
Okay.
Some amphetamines as well.
Professor Stapleton and then Professor Green.
Yeah, I've got a sort of general question really, which is, because I know nothing really about civil law systems. So the question is, when you're now looking at redoing the code, to what extent does the straitjacket of these complicated earlier discussions where you're trying to cram something into the code, how do they carry over? Or can you just say, all right, we don't have to worry about what we have now in the past code, we can just have a blank slate and take loss of a chance, for example. Now in the UK, we have loss of a chance for the solicitor's case, and in fact we have it whether you can recover even if the chance of you winning the claim was less than 50%, whereas in the States they have different rules, as I understand it, between different jurisdictions, whether you have to at least be over 50% and then you might get it all. So say you're redoing the code and you want to have a provision about loss of a chance, do you just say, well, let's look at the options other jurisdictions have, what would be a good idea? Is it a free-floating discussion, or is it still somehow influenced by this, as I say, this very confined discussion of these earlier provisions?
It depends on which side you're on. So the original draft clearly was completely open-minded and said, well, of course we have the tradition, and we want to stick with the tradition, but as it stands now, not in 1811 or 1797, because the actual code, the West Galician code, was actually just a trial zone. So West Galicia was simply picked at random to have a test run for the ABGB, and then once it turned out to be successful, they continued it. The idea was of the original draft to basically continue the tradition to the extent that it works great in practice, disregarding the fact that the novel approaches used by the courts may not be fitting well into the original language. Of course, the original draft was open-minded towards novel solutions and looking around in a comparative way. The opponents said, well, no, you can't do that. We don't want to change the sacred language of the code, and they want to preserve the language as it stands to the extent possible, also at the expense of continuing misapprehensions of the law if you read the bare words of the code. So if you read the full text of the opponent's draft, it is, to my perspective, it's inconsistent, and it doesn't pay attention of what the Supreme Court does with it. And I think the language of a code, if you take about the task of reforming the language of the code, you should at least update it to the way that is used nowadays. The problem is that the opponents of the reform draft actually also dispute the fact that it needs reform. And they said that it's completely hasty to go ahead with and too speedy to go ahead with reforming the draft. But Gerhard Wagner commented on that and said, well, if you have the first reform of the law of torts after 200 years, you can't really speak of too hasty.
You see, to me, it's an interesting comparison with the restatement process, because yesterday or the day before, Mike was saying that he has sometimes qualms about stipulating fresh language, even if that might clarify the law, because there is this worry that you've got a different project. I'm just wondering to what extent maybe you're saying that some parts of your debate, people think of it more as a restatement and some people think of it more as what we'd, modernizing the law with a fresh slate. So it's just what perspective you have on it.
The prime idea, even of the original draft, was more of a restatement. So thank you for that comparison, because but restating in the sense of a snapshot of today.
Yes.
But of course open towards potential changes even, where it seems necessary in order to make it more coherent. So for example, as I said, the original draft suggested to expand proportional liability also to the hunters' cases. And that is clearly a major change to the past. But there are not that many bold developments of that kind in the other language of the drafts. So it's really more like a restatement, but with a slight openness towards modifications for the sake of completeness of the overall picture. Yeah.
Thank you. Any more questions? Yeah, Professor Green, please.
I just, Jane, on your comment, it seems to me that drafting a civil code is a very different endeavor from doing a restatement. If you put the language in the civil code, it will be used, right? We can be sure of that. My skepticism about restatements is the extent to which they will influence courts in their usage. So I see that endeavor as being much freer to do what they want to do, because we know that courts will accept the language in the code. I wanted to go back to your discussion. And if I understood your answer to his question, Bernard, it was that the basis for liability, whether it is a strict liability cause of action or a negligence cause of action, along with the question of causation, would be used together to proportional liability. That's at least modestly different
Yeah.
from what Joe was talking about in the United States, where it's not the cause of action, but the degree of culpability of the defendant. So some defendants are held liable, strictly liable, may be quite culpable, although it's not required for the cause of action. And then we would look at their individual culpability, right? Maybe, and along with just a comment, and that is you're talking about holistic views where one could substitute for the other. Brought to mind an American scholar from LSU, Rex Malone, who in a series of articles argued that causation or the degree of belief in causation was adjust for the culpability of the defendant, so that more highly culpable defendants, we would be less demanding about proof of causation than for modest. And that struck me as being very much analogous to what you were talking about. Finally, I want to ask you a question about your preferred result to the Hunters case, which, as I understood you to say, it would be joint and several liability.
That's the existing solution. That's clearly the outcome of the code language. But the future solution that is suggested by the reform project would be proportional.
Right, but I thought you said that your preference would be... No. No?
No, I'm in line with the modern approach.
Okay, all right.
I'm also representing the European Group on tort law, so I have to.
Okay.
No, just kidding. But coming back to your point about the weighing sort of, or putting both causation and culpability into one, on one side of the scale. I mean, you can compare this a little bit to the German solution, but I think the Austrian solution is a bit more, well, open-minded, or whatever you may put this. As you know, in Germany, if you can prove that the defendant acted with at least gross negligence, then you have a reversal of the burden of proving cause. So we don't go that far. So we still insist on at least proving a probability of causation. So we don't reverse the burden of proof, but of course it's along the same lines. So the scale tips because of the culpability of the tortfeasor. So it's not a unique Austrian development, but we just don't go that far as shifting the burden of proof.
Professor Sanders, please.
I wasn't going to say this earlier, but since Mike made this comment, I think it's worth reflecting. As you know, at least formally, outside Professor Malone perhaps, American tort law absolutely refuses to trade off degrees of fault for causation. But we have a substantial body of jury research in the United States that makes it very clear that in practice, that's exactly how American tort law operates. Jurors routinely trade off degree of fault for causation, and indeed, of course, trade that off for damages as well. And so there's very much of a mishmash in terms of what juries actually do. Sounds very similar.
Yeah.
Any more questions? We still have time for a couple of questions, I think.
Well, actually, it's not a question for you, Bernard, but it's a follow-up to Carlos. Interesting when you talked about the Argentinian code about someone, if something falls from, and unless I don't understand what exactly happening, I'm surprised that you accept it as non-controversial, because it seems to me that if you talk about condominium, so some people that weren't at fault and weren't a cause would be held liable, which is something that I think most of us agree that is problematic. But I found it surprising that, as I said, that given your position, that I thought that you endorse it, that you think that this is not problematic. So what would be the difference between that and the red cab example?
I say that Argentinian lawyers don't find it problematic. For me, it's not problematic, but for different reasons. Because according to Argentinian law, the condominium is a sort of a person, so to speak. So you could think that what fell down belongs to everybody. It's sort of a collective agent. So I think when in all these cases, when you could predicate that the action was collective, this is not a problem.
May I assume that the condos are also insured as such?
Pardon me?
Are the condos insured?
Yeah, usually, yeah.
That's what I thought.
By the way, I was in China a few years ago, and one of the people there was saying that they just changed this. Yeah, a few years ago I was in China, and they said they just introduced exactly that provision with apartment buildings.
Mm-hmm.
Yeah. It's one of the first instances of a solution which is very clear.
No, we have it in the Austrian code as well.
So they have
It's not an Argentinian solution. It's something which it comes from the Roman law to French code and then to the Latin code. It is the first instance of
before the French code, it was in the Westphalian code.
No? But it's a solution of efficient, I would say, no? Because it was. But
Isn't that the actual forces at the
Thank you. No, I just wanted to say what you were saying, that it was Roman law solution. And just as James Stapleton said yesterday about Summer and Tice, we're trying to explain with all rational solutions, which are actually very ancient. And I don't know Roman law good enough to know how they justify that, if they ever try to justify it with, abstract reasons.
Exactly. Yeah. Well, at the time, of course, Romulo didn't have the condo idea. So it's just one building, and it was attributed to one person.
Yeah, it was only one owner in original law, but I think that you could, the tenants could be made liable. Liability would not be, well, I'm not quite sure, but I think liability was not on the owner of the condominium in Roman law, but rather on the occupiers. Yeah. Yeah. Well, for the owners.
The keepers.
What would happen if it was a hotel and all the guests It would. Yeah, this is. But not to that's what not to the hotel guest. No, to the hotel guest. No, I think so. In China, it would. The hotel guest. Would be like. Well, probably everybody. I mean, would impose liability. And joint and several? So sue any one of the hotel guests and recover your full damages. You know, well, I have a Chinese scholar who says it is. So you read the code, Richard, and tell us what it says.
There's another question?
In some Latin countries, there is a provision in the Spanish Civil Code that expressly states that in this case is the principal person of the house who is liable. And the principal person of the house who is liable is the owner or the person who has rented the house. And then this person, if someone else, if there was a meeting of people who just throw the thing out of the window, then it will have to have a right of recourse against the tortfeasor, you know?
But identifying the tortfeasor instead of making...
Yeah.
Yeah, well,
It's a express provision.
Argentina is more liberal.
Yes, Professor Jordi Ferrer.
It's not exactly a question, but simply I really appreciate that you begin your paper taking into account the question of proof in causation cases. But, and I really appreciate it because I think that in general we concentrate our attention in the substantive problem of causation and not in the procedural problem of proof or evaluation of evidence, etc. And particularly in the point of the standards of proof that we used in order to decide this type of cases that are generally so problematic and not absolutely simple. Mm-hmm. And in this point, I think that we need a treatment that takes into account the problem that this aspect is so problematic. Mm-hmm. And I think it is not clear in the paper in this case. Let's take an example. In medical malpractice cases, for example, you show us that it suffices for the defendant, for the patient, to show a high probability that she would not have suffered the injuries at stake if the defendant has acted as necessary under the circumstances. Then the standard is the high probability. So vague, I don't know what it is, high probability, etc. But this is not exactly my point. Okay, high probability, it seems more probable than not. Okay? It's a very strict standard. Not certainty, but more probable than not. Okay, this is the standard for the patient. And for the doctor? What needs the doctor in order to win the case? The doctor could, in turn, rebut such proof by showing that another possible cause was more likely than not. More likely to have triggered the damage to the claimant. More likely. It is not necessary, in my opinion, that for the doctor the standard was was more likely than not. If the standard for the patient is high probability, the standard for the doctor is to show that the doctor needs is to show that the defendant's claim is not at high probability. But it is not necessary to show that his case is more likely than not.
It's not more likely than not, more likely than what the patient established.
Sorry?
It's more likely than what the patient established. It's not more likely than not.
No. Let's take for the sake of the argument, let's use numbers, and I think we cannot use numbers in order to define the standards of proof. But for the sake of the argument, in order to show what I want to say, if the standard for the patient, for the defendant, is to show his or her case at 0.8, for example, of probability, the standard for the doctor is to have his case, his or her hypothesis at 0 plus 2, 1, 0 plus 21. If the doctor shows that her thesis have a probability of 0.21, then the hypothesis on the contrary of the patient is less of 0 plus 8. The doctor doesn't need to show that his hypothesis is more likely than not.
No, we're talking about another cause. He must show another cause, because otherwise it would be the same argument. You cannot prove in the same trial. You cannot prove that the patient cannot prove 80%, and the doctor at the same point, on the same point, proved 21%, because either one or the other. We're talking about another possible cause.
Okay.
That the doctor, for example, the patient says your misconduct, dear doctor, was I don't know, 60-70% likely to cause my loss. And then the doctor has to prove that a precondition of the patient had a very high degree of likelihood, and a much higher degree of likelihood to cause the loss, so 70-80%. So we're not talking about the same cause here.
No, it's not the same cause, but if the patient needs to show that the cause that he intends to be the cause, the hypothesis that he of an act that he intends to be the cause of the damage is X, and not any one cause, but X. And the probability that the cause was X is 0 plus 0.8, then the doctor only needs to show that another probability, another cause have the probability 0.21. If another, someone other cause have the probability 0.21, then this X hypothesis couldn't have 0.8. But my general comment is simply that we need some evolution, I think, to work in some evolution of standards of proof in civil cases and especially in cases in which is involved causation. And generally we concentrate our attention in the problems of the different types of causation and which responsibility and which and the way in which we prefer to distribute the responsibility in this case and the other case, and doesn't pay sufficient attention in standards of proof problems, I think.
Well, the problem is that judges simply only pretend to know what they're doing. Because judges never say, I'm 65% sure. They simply say, I'm sure according to whatever standard that just applies to me. And there's no way of verifying this. Because, I mean, to follow up on the discussions of the previous days, in Austria it's really a question of belief. We're not talking about any objective or pretended objective proof. We're talking about the belief of the judge. And you cannot prove whether the judge believes something according to a certain likelihood. He just says, I'm sure. And so you don't actually argue about those percentages in real life. That makes it more complicated. I mean, the problem only arises in cases where you have experts who say that there is a 65% likelihood of that. Then you come up with those problems. And that's why, for example, medical malpractice cases are the first ones where this actually becomes an issue. Because in other instances where you don't have the experts quantifying the likelihood, judges simply don't deal with that. They just pretend that they are convinced with a degree of likelihood that is almost certainty. But what does that mean? I mean, how can you quantify the belief of the judge? That's always a problem. But in the case of medical malpractice, the lowering of the standard simply happened because medical experts are getting more and more cautious to say, well, this is with a likelihood that is close to certainty. You will hardly find medical experts who say, I'm 90% sure that this was the cause. So that's why the court then ended up with lowering it. But in real life, I think they're doing the same with all other cases as well. They just don't have to deal with figures.
Yes, but if we reason straight in that way, that means that the mere expression standards of proof doesn't mean anything.
Yeah.
Because if we say, oh, what the judge thinks, he thinks. Okay, what is the standard? Higher, lower, there's no standard in this case. And one of the consequences of what Jordi was saying is this, reasoning from the procedural point of view. I really cannot understand why, in the case in which I may prove, plaintiff, may prove my point of causation at, let's say, 30%, why should I take the 30% of my credit? Because if I prove it at 30%, I simply didn't prove the fact. Mm-hmm. Because I didn't reach the standard of proof. And if I don't prove the fact, I lose my case. I'm not entitled to get the 30% because I gave a 30% proof of my case. That's it. There is the basic rule of the burden of proof. Mm-hmm. If I don't reach the point required in criminal or in civil, if I don't reach that level of confirmation of the fact I stated, I simply lose my case. I'm not entitled just to have a portion of what I claimed if I didn't prove satisfyingly that I'm right. That's why I don't understand, at least in part, this way of transforming a degree of likelihood of causation into the entitlement to have the same share. This is the likelihood of causation, is not the share of the credit. So I'm not clear about that.
Well, but take the 300s. In all three, with the 300s, you have 33.3% likelihood of each. Yeah. So if you sue one of them, you would not.
I can lose my case because I'm not showing that he is the wrongdoer. Yeah. If I prove it at 33%, I'm not proved the case. Stop. Yeah. From the procedural point of view, I'm losing. Mm-hmm. if I'm doing that.
You don't believe in liability in the hunter's cases then?
Sorry?
You don't believe in liability in the hunter's cases then?
Liability and proof, in my opinion, still are a different kinds of problems. One can make any compromise one wants. And correctly, you yesterday saw, if I understood you well, that this is the suboptimal solution. Because the optimal solution should be there is no case. But if we want to give anything to the victim, doesn't matter how, and doesn't matter why, that's a different. This is a problem of equity, this is a problem of other consideration.
I wouldn't like to interrupt the discussion. I think that we can keep on discussing, having a coffee. The coffee is ready, so thank you very much to speak.